for today.
No issue.
The reason is this, my lord, and I'll be very candid with your lordships. What is the reason? Lord, after the Renault judgment and after advent of internet and its progress which we have seen, there is no judgment of any Indian court which takes into consideration the progress made by internet, its pervasive impact on the society's thinking process, society's values, societal values, etc. No judgment has taken care of the algorithms which are used for the purpose of content curation and kind of an editorial intervention indirectly, may not be human intervention, but by machine. And my lord, collection of metadata of individuals and their submission that now we are still not touchable. We cannot be touched. We can touch private information, personal information of individuals and curate our content, but we cannot be asked. Another question, my lord, which may, my lord, be a relevant factor is, your lordships have seen in the judgment of the Supreme Court of US that even US Supreme Court complains that they don't share their algorithms even with the Supreme Court of US. They are based in US. They are governed by laws of US. Third, similar safe harbor provisions with similar exceptions, exception to exceptions, exist in almost all jurisdictions in the world, where Lord, all intermediaries are following, and this is the only one social media intermediary, Lord, which has a problem and which is before. Now, your lordships may, Lord, take my written submissions,
yes,
and
sir.
I will skip most of it.
Yes, yes, no problem.
My Lord, when
no, you can go at your pace, sir. No
no,
problem.
my Lord, when my Lord, a person argues before the honorable judge for more than half an hour, but he knows, my Lord, what to argue, what to skip, and arguing basic points before a particular judge
Yes.
is almost contemptuous. That means that you know that the judge would not understand. I know, my lord, your lordship's grasp is much faster than, my lord, our grasp. I'll leave that, my lord. Kindly come to page 30. I'll leave most of the part. I'll just highlight what are the broad propositions with which I would like to assist the court, my lord.
And I will definitely go through everything and then.
I am very sure about it. Therefore, with that assurance which
Yes,
I have given to myself, my lord, I am skipping. Lord, kindly come to page 30, para 67.
Yes, sir.
Just to take, my lord, the thread from where I left.
Yes, sir.
Further, the European Union's regulatory response has recently culminated in the Digital Services Act, effective 2024. The DSA retains the basic safe harbor for mere hosts, but adds significant due diligence obligations, especially for very large online platform. What we in our law say, substantial, not significant social media intermediary. It is submitted that under the DSA, platforms above a certain size must proactively assess systematic risk on their service, such as dissemination of illegal content, impacts on fundamental rights, electoral manipulation, etc., and put in place reasonable mitigation measures. It explicitly allows courts or authorities to issue orders to remove illegal content and even expect quick compliance. But not pausing here only for a minute. In one of my, my lord, one of the paragraphs of my judgment, my lord, I have said that Shreya Singhal does not lay down the correct law, to which the answer of the other side is legally absolutely a correct right, that can never be argued before the Honorable High Court, because your lordships cannot say. But nonetheless, I have retained, my lord, that submission, so that eventually, my lord, I may request, my lord, a bench of larger combination to reconsider Shreya Singhal.
There.
Yes, yes. Not here. I will not argue that here. But, my lord, that's the reason. You are absolutely right that cannot be argued here, and I am not going to argue it here. But I have to place it, my lord, in the pleadings before the High Court, and we may request, my lord, the Honorable High Court to consider maybe in a 3-judge bench combination that what it was in 2014 and other factors, Lord, I am not going into. Now, please come to page 31. Lord, these are the facts I have given.
Yes.
As per the available documents with us. I am not reading them. What it is, my lord? What is the compliance of X, the petitioner before your lordships, in other jurisdictions? In some of the jurisdictions, they have imposed fines, they have filed an appeal, They are censured. Some of the jurisdictions.
Stop, my learned friend, my lord. I just want to make one point.
No, no, I'm coming to that. Please give me a minute.
Para
This-
69 is part of the written submissions,
Huh.
but they are not pleaded. So, I mean, if you just simply say, you have been censured by that court, I don't know what happened in that court. Then, my lord, if,
It is said appeal is also filed against the order in the
but
other
I,
column.
my lord, I don't know what order has been passed, I don't know what was the context.
That means-
So, my lord, I just want
My-
to
you can
take
remind
that
us.
fact because to
You
make
can-
an insinuation against my client in a written submission on facts, I mean, all about Reno, subsequent development of the law, of course, my lord, learned solicitor is perfectly justified. But to make an insinuation against my client.
No, you can
that-
reply.
My lord, my learned friend is absolutely right. These are factual assertions.
Yes, yes.
And must come in the pleadings and not in the written submissions. But I have placed, my lord, only to show that there are intermediaries who are not complying with the guidelines, and my lord, forget X, to show to your lordships that there is a concern of every jurisdiction, every country is grappling. I have given instances of X, but I can give instances of, my lord, other intermediaries also, but I didn't want to burden. That any deviation from, my lord, the exception to safe harbor, like, Lord, taking care, due diligence, etc., is viewed very seriously now by almost all jurisdictions. I leave it at that, my lord, I am not reading it. Lord, now please come to, my lord, the head at page 33, and I am not going to read this heading. My lord, all contents on the intermediaries is not relatable to
19.
Article 19(1)(a). My lord, all companies have their Twitter accounts, X accounts. My lord, now we are
X.
accustomed with the word Twitter. My lord, they propagate their, my lord, idea of their policies, their progress, etc., These are all advertising Twitter accounts. Many of them would be advertising, and therefore, my lord, commercial speech is, my lord, very, very restrictively protected by 19(1)(a) rights, my lord. That's what I have said. Now directly come to, my lord. My lord, I have given the judgments. I'm not reading the judgments.
Yes.
Now, my lord, the next point. Let us see, my lord, on the brass facts of this case. What is under challenge is Rule 3(1)(d). Rule 3(1)(d), the last part. Last part says, whatever is unlawful, you are cautioned, you are not punished, you are not directed to take them. You are cautioned that this is unlawful. The remedy is not to challenge 3(1)(d). If they are aggrieved, they will have to challenge the law which makes it unlawful. I'll give an illustration. My lord, I'll just read, my lord, D1 once again, my lord.
Yes.
An intermediary on whose computer resource, I'm sorry,
Yes, sir. 3(1)(d).
yes, any intermediary on whose computer resource the information is stored, hosted, so and so.
Yes.
Kindly come to the last line. Or any information which is prohibited under any law for the time being in. Suppose I'm giving an illustration in, say, Copyright Act or Trademark Act. There is a prohibition that nobody would use the trademark which is registered in my name. It's prohibited to use it by anyone else. So it would be something if, my lord, some Twitter user publishes my registered trademark or something which is a copyright of mine, my lord, on that in his Twitter account, and I caution him. What I do is I notify him, the Twitter, that this is prohibited under law, particular law. If they are aggrieved, they can say that that provision is unconstitutional. It can be published. Either user can say, or if they are aggrieved, they can say. But you can't shoot the messenger. You can't say that, no, don't even inform me what is prohibited by law. I'm putting a question to myself, my lord, can the government, by making statutory regulations, not have a provision to inform them that this is something which is prohibited by the law of the land? How can, my lord, I'm posing a question to myself, that become unconstitutional? You challenge that law. Suppose, my lord, there is a law that nobody would criticize the government of the day, hypothetical law, and somebody puts a post, my lord, criticizing the government of the day. They can very well challenge that law, but not 3(1)(d). 3(1)(d) is a generic provision. Anything which is contrary to law will have to be informed. But now, please come to page 42.
Yes.
And again, my lord, I'll skip what is not necessary, my lord.
Yes.
But, my lord, two judgments came immediately after the constitution came into force.
Yes.
One was Ramesh Thapar and another was Brij Bhushan. Well, Lord, what was the ratio of that judgment? If I were to say in one line, the ratio was that Article 19(2), which provides for reasonable restrictions, are to be strictly construed.
Construed.
There is no elasticity. And the parliament was acting, your lordships are aware, till, my lord, the first election took place.
Yes, yes.
The first parliament was also acting as constituent assembly. So first parliament, acting in its capacity as a constituent assembly, said that now because of these two judgments, and they discuss the judgments, both the judgments, they say that we will have to do something about it, because there may be situations where a particular instance may not fall within strict four corners of the, my lord, contingencies given in 19(2). It may not be sovereignty of India. It may be something relating to that. It may not be public order, something relating to that. And therefore, my lord, I have given, my lord, the debate. Debate is 900 page. So I have been selective, my lord, in giving the debates which is relevant for the present purpose.
Yes.
But please, my lord, come to what Prime Minister Nehru says. 2 or 3, my lord, I'll just read for my satisfaction.
Yes.
At page 44, the Prime Minister and Minister of External Affairs, we have come up here naturally because after the experience of a year and a half or so, we have learned much. We have found out some, if I may say so, errors in drafting or in possible interpretations to be put on what we have drafted. That is but natural. And the House will also remember. Then, my lord, kindly see the Dr. Ambedkar. I'll skip that. Your lordships can read it at leisure.
Yes.
Detention laws are something quite different, because Ramesh Thapar, etc. dealt with that. That is in nutshell, Sri Kamath, what a poor nut. Sri Kamath must have said something, and everything was get recorded. And in the entire debate,
Yes.
Mr. Kamath and Dr. Ambedkar were opposing each other.
Yes. Yes.
And Mr. Kamath was a little more vocal about his personal views on
Yes.
the individuals.
Yes.
The case for amending Article 19 of the Constitution. It is next important to consider why the Supreme Court and various state high courts have come to this conclusion. Why is it that they say that Parliament has no right to make a law in the interest of public order? But in the interest of was not the word in the original section.
Yes.
And that they are introducing. In the interest of public order or in the interest of preventing incitement to an offense? That is a very important question. And it is a question about which I am personally considerably disturbed. For this purpose, I must refer briefly to the rules, etc., my lord. Now, please come to, my lord, page 45, only bold part.
Yes.
How has this happened? This has happened because US Supreme Court, although it was the first court in the world which was called upon to reconcile the fundamental rights of the citizens with the interest of the state, after a great deal of pioneering work, came upon two fixed principles of the Constitution. But Lord, kindly see how lucky we as Indians are. Lord, the formulation of the Constitution was in the hands of people like Dr. Ambedkar, who were not only aware of Indian scenario, but the global scenario, how Constitution is evolving everywhere. And, my lord, we got best of the legal minds, my lord, to this. He referred to police power, which is used, my lord, expression used in America. We say governmental regulation. Police power in America is equivalent to governmental regulation. Please see, my lord, in this context. Reconcile fundamental rights of the citizen with the interest of the state. After a great deal of pioneering work, came upon two fixed principles of the Constitution. One is that every state possesses what is called in the United States police power of doctrine. No, it is governmental intervention or governmental regulation in the Indian context, which means that the state has a right to protect itself, whether the Constitution gives such a right expressly or not. They read implied power. The police power is an inherent thing, just as our courts have inherent powers in certain circumstances to do justice. It is a result of this doctrine of police power that the United States Supreme Court has been able to evolve certain limitations upon the fundamental rights of United States citizens. The second doctrine which the United States Supreme Court developed and which it applied for purposes of interpreting the Constitution is known as doctrine of implied powers. according to the decisions of the Supreme Court, if any particular authority has been given a certain power, then it must be presumed that it has got other powers to fulfill that power, and if those powers are not given expressly, then the Supreme Court of United States is prepared to presume that they are implied in the Constitution. They are trying, the Constituent Assembly is trying to make 19(2) contingencies elastic, which was read as static in Ramesh Thapar and Brijbhushan, that you cannot travel beyond these words. They say that no, we will have to sometimes to give meaning and effect to the provision itself, that we have to read it expansively. Now, your Lordships may kindly, my lord, turn the page. Now, my lord, on the next page, the top line.
Yes.
Lord, now Dr. Ambedkar refers to those two judgments, Ramesh Thapar and Brijbhushan. The reason why the judges of the Supreme Court do not propose to adopt the doctrine of police power, that is governmental regulation to be presumed, is this. So far as I am able to understand, the Constitution has enumerated specifically the heads in clause 2 under which Parliament can lay restrictions on the fundamental rights as to the freedom of speech and expression, and that as Parliament has expressly laid down the heads under which these limitations should exist, they themselves now will not add to any of these heads which are mentioned in clause 2. That is sum and substance and the construction that you will find in the case of Thapar's judgment, which was delivered by Mr. Justice Patanjali Shastri. Now, please come to the next page again, Dr. Ambedkar.
Yes.
The point that I was trying to make to the House is that on account of the declaration by the Supreme Court that this Parliament has no capacity to make a law in certain heads under 19(2). The question before the House is, can we allow the situation to remain as it is, as created by the judgments, or we must endow Parliament with the authority to make a law? Can we make the heads elastic? My lord, thereafter, my lord, matter goes to the select committee, and my lord, select committee also says something. Please directly come to my lord now what Mr. Rajgopalachari says. My lord, first, my lord, page 48.
Yes.
Jawaharlal Nehru. See, Nehru continued to stress the importance of approaching the Constitution in a dynamic spirit. That it is an evolving document. It is not static. What was true in the year 49 may not be true in the year 2026. It's a living document. A constitution must be respected if there is to be any stability in the land. A constitution must not be made the plaything of some fickle thought or fickle fortune. That is true. At the same time, we have in India a strange habit of making gods of various things, adding them to our innumerable pantheon and having given them our theoretical worship, doing exactly the reverse. If we want to kill a thing, we deify it. If you want, you make a god out of it, and the thought goes. That is the habit of this country largely. So if you wish to kill this Constitution, make it sacred and sacrosanct, certainly. But if you want it to be a dead thing, not a growing thing, a static, unwieldy, unchanging thing, then by all means do so, realizing that that is the best way of stabbing it in the front and in the back. Beautifully, that if you make it static, you stab the Constitution from both the sides. Lord, now see Rajgopalachari, Lord, intervenes. One of Lord, the legendary stalwarts and my lord, a scholar in his own right. My lord, please come to page 50. I'll not read, my lord, the whole, but my lord, kindly come to page 49.
Yes.
How he explains. My lord, he is also fully conversant with the law and how laws are made. We were not, my lord, in the hands of only laymen. My lord, if your lordships must have gone through Constituent Assembly debates, even the laymen in the sense that they were not legally trained minds, they have also contributed immensely by their foresight. That this is what may happen. Now, Dr. Rajgopalachari, last part, the highlighted part. An incitement to offense is not necessarily an abatement. An abatement has to be directed to a particular offense and it should be proved in a particular manner. But surely we do not want people to say on the one hand, there should be no black marketing, and on the other hand say, people should be allowed to write and freely circulate statements and expressions saying, we honor man who break this law and we want you to break the law so that the law itself may be changed. We do. So he's now dealing with the freedom of expression
Yes,
and the necessity to change or make elastic the heads under 19. We do not want that kind of contrary attitude with regard to crime. Let us pass laws with reference to crime with all care that we can. But having passed that law once, let us not stultify ourselves by saying that freedom of expression must be any man may circulate stuff inciting people to break that law and reduce it to nullity. Now, my lord, the bottom highlighted part of Dr. Rajgopalachari, this clause only permits legislature to take notice and take due measure to prevent such incitement to offense, and that is the reason behind this clause and not any intention to curb the freedom of speech. Freedom of speech, put most briefly, is a thing to be used and not to be abused. Of every natural right, there can be use as well as abuse, and governments and parliament and legislatures have to prevent abuse, and it is not interference with the freedom if we prevent that abuse. And when they say clause was making it elastic by adding the word in the interest of and incitement to offense. My lord, that was also added. Now, your lordships may, my lord, kindly come to
To,
how
to
the-
end that, I think the para 105,
Yes.
what began as discussion is beautifully put, and then the discussion goes on.
Yes, my lord. He
Now,
says,
what is this right we are
right
discussing?
and
Discussing, the right we are discussing is natural right,
Yes.
right to freedom of expression. It is a natural right. No one can claim that natural right is like a right given in a clause of lease of an insurance policy to be enforced like Shylock's pound of flesh.
yes, my lord.
This is what he begins, and then,
So, my lord, what he says, my lord, I skipped that, I read it. What it possibly he tries to say, and the beautiful philosophical content, that certain rights are natural rights. They are not conferred upon. My right not to be abused is my natural right.
Exactly.
It is recognized by the constitution, not given by the constitution. My right to privacy is my natural right. It is recognized under Article 21. It's not given by Article 21. He starts with that.
starts with that and explains why it
Explains,
is
my lord.
important that expressions are controlled.
And, my lord, why incitement to an offense is relevant, my lord.
Yes.
Now, your lordships, my lord, come to, my lord, now, my lord, this constitutional amendment passes. And, my lord, the static heads, sovereignty and integrity of India, friendly relations, etc., including public order,
Yes.
now has one prefix in the interest of. Now, my lord, how that expression in the interest of is, my lord, understood by our courts. I will read only one or two judgments, not read every judgment, my lord. But the first judgment after this amendment was Patna High Court judgment. And, my lord, that is, my lord, it may assist your lordships, my lord. That is,
Devi Soren.
yes, my lord. Kind have a look at, my lord, page 52.
No, Devi Soren is quoted in VG Row.
Yes,
That is what is here.
Yes, my lord. It is important in this context to bear in mind that the test of reasonableness, whenever prescribed, should be applied to each individual statute impugned, and no abstract standard of general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied thereby, that is where the nature of the medium comes in the context of these facts, my lord. That what is to be remedied and urgency for remedying it, because it spreads like wildfire across the globe, should all enter into the judicial verdict. In evaluating such elusive factors and forming their own conception of what is reasonable in all circumstances of a given case, it is inevitable that the social philosophy and the scales of values of the judges participating in the decision should play an important part, and the limit to their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint, and the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all, and that the majority of the elected representatives of the people have, in authorizing imposition of the restrictions, considered them to be reasonable. That is also one of the consideration for the court while exercising power of judicial. My lord, in 1952, my lord, thereafter, my lord, the first judgment of the Constitution bench is Ramji Lal. I'll read only highlighted part on page 53 and nothing more.
Yes.
In the first place, my lord, EL is typo, it's clause. Clause 2 of Article 19 protects a law imposing reasonable restrictions on the exercise of the right to freedom of speech and expression in the interest of public order. So they put it under the inverted comma, that this is now an inserted clause, which is much wider than for maintenance of public order. If therefore certain activities have a tendency to cause public disorder, a law penalizing such activities as an offense cannot but be held to be a law imposing a reasonable restriction, even if it is a penal law. This is not a penal law. This is not even an injunction. This is only a caution. This is only lifting a conditional exemption, that you are exempted subject to conditions.
There it was 295A interpreted.
Now,
Yes.
activities cannot be held to be a law imposing in the interest of public order, although in some cases those activities may not actually lead to a breach of pleas or public order. Lord, this was a challenge to section 295A of the Indian Penal Code, that eventually your act may not result into the actual public order, but even if the action is relatable to it, if action is taken in the interest of public order, it will have to be justified. It will have to be, my lord, upheld. My lord, now please turn the page over, my lord. And Virendra versus State of Punjab, again a constitution bench, my lord. This was case of a newspaper.
Yes.
And the Punjab Act was under challenge as violative of 19(1)(a). Please see, my lord, para 114, only the bold part. The powerful influence of newspapers for good or evil on the minds of readers, the wide sweep of their reach, the modern facilities for their swift circulation to territories distant and near, must all enter into the judicial verdict, and the reasonableness of restrictions imposed upon the press has to be tested against this background. My lord, this is the judgment of the year 57, where they say that even the newspaper has a wide reach. Now, my lord, it's uncomparable. Then second highlighted part, our social interest ordinarily demands the free propagation and interchange of views, but circumstances may arise when the social interest in public order may require a reasonable subordination of social interest in free speech and expression to the needs of our social interest in public order. Lord, this is again a constitution bench judgment with regard to a media, with regard to Article 19(1)(a), right, and analyzing the reasonableness of the restriction. My lord, then, my lord,
Next 4 lines also is very good.
yes, my lord.
Our
Our constitution recognizes this necessity and has attempted to strike a balance between the two social interests, competing
Yes,
interests. It permits the imposition of a reasonable restrictions on the freedom of speech and expression in the interest of public order, and on the freedom of carrying on trade or business in the interest of general public. My lord, then your lordships may, my lord, see the next judgment is, my lord, Phagera prison. My lord, this was an oral speech. My lord, I'll come directly to page 56.
Yes.
And the top, my lord,
Yes.
bold part.
Yes.
This observation also indicates that public order is equated with public peace and safety. Presumably, in an attempt to get over the effect of these two decisions, the expression public order was inserted in Article 19(2) of the Constitution by the Constitution First Amendment Act 1951 with a view to bring it offences involving breach of purely local significance within the scope of permissible restrictions under Clause 2 of Article 19. After the said amendment, this court explained the scope of Ramesh Thapar and state of Bihar, in state of Bihar. That case was concerned with the constitutional validity of Section 4(1)(a) of the Indian Press Emergency Powers Act. It deals with the words or signs or visible representations which incite or to encourage or tend to incite or to encourage the commission of any offense of murder or any cognizable offense involving violence. Then, my lord, para 11 of that judgment. But in India, under Article 19(2), the wide concept of public order is split up under different heads.
Yes.
It enables imposition of reasonable restrictions on the exercise of the right of freedom of speech and expression in the interest of security of state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. All the grounds mentioned, Lord, before this, there was a confusion that in the interest of applies to the next head only, not to all heads. For the first time, Lord, the Constitution bench clarifies this. All the grounds mentioned therein can be brought under the general head public order in its most comprehensive sense. But the juxtaposition of different grounds indicate that though sometimes they tend to overlap, they must be ordinarily intended to exclude each other. Public order is therefore something which is demarcated from others. Well, then para 18. The foregoing discussion yields the following results. 1. Public order is synonymous with public safety and tranquility. Tranquility concept is brought for the first time. That public order is not that people would start with swords and lathis in hand. Tranquility of the public also can be damaged in various forms. It is the absence of disorder involving breaches of local significance in contradistinction to national upheavals such as revolution, civil strife, war affecting the security of the state. And second, there must be proximate and reasonable nexus between the speech and the public order. Now, my lord, come to American judgments on restricting free speech cannot be relied upon.
Madhulimaye.
Madhu Limaye, Babulal Parathe, etc., etc. I will not read them.
In fact, public order and public tranquility, they differentiate in Madhulimaye and say public tranquility as defined in American jurisprudence would not be helpful here.
Yes, my lord. Madhu Limaye is 7 judge.
Yes, 7.
It's a 7-judge bench judgment, my lord. And, my lord, I have quoted the relevant part.
Yes.
But, my lord, there is one thing in Babulal Parathe. I want to just cite it, my lord.
Yes.
Please see Babulal Parathe, my lord. It's a constitution bench, 5 judges.
Yes.
Para 23.
Yes.
Argument that the test of determining criminality in advance is unreasonable is apparently founded upon the doctrine enumerated in Shank case, that previous restraints on the exercise of fundamental rights are permitted. Your lordships would recall,
Yes.
Shreya single judgment
Shank case.
relies on this Shank judgment, my lord, that shouting fire in the 5-judge bench has specifically said that this does not apply to Indian scenario, and confirmed by the 7-judge bench in Madhulime. But Shreya Singhal, my lord, this will have to be argued before the Honorable Supreme Court. But Shreya Singhal relies upon a judgment which is held to be not applicable in the Indian context by 5-judge bench, confirmed by the 7. Lord, now kindly come to page 61, para 10.
Yes.
Lord, this
Ram
is
Leela
Ram Leela Maidan incident, my lord. Para 10 only, my lord, I'll read. The fundamental right enshrined in the Constitution itself being made subject to reasonable restrictions, the laws so enacted to specify certain restrictions on the right to freedom of speech and expression have to be construed meaningfully and with the constitutional object in mind, not mechanically. Freedom of speech and expression, untouchable. Don't touch it. Now, my lord, I'll skip that, my lord.
In fact, Shank is again quoted and
Yes, my lord, the race star, my lord, that
para 8, they say,
Yeah,
not
yes.
an absolute right, but
Yes,
that's the difference between our constitution and American jurisprudence.
absolutely. Lord, these are all judgments on this proposition that American judgments on freedom of speech and expression can never be relied upon while defining the contours of Article 19(1)A read with 19(2) in the Indian context. All these judgments, my lord, going up to page 66 are those judgments, my lord.
Yes.
My lord, last one is Arup Bhuyan, 2023, 8 SCC.
Yes.
There again, my lord, Benderberg was, my lord, cited before a 2-judge bench. Lord, we requested and the matter was placed before the Honorable 3-judge bench.
Yes.
And the 3-judge bench, my lord, declared two-judge bench judgment to be not a good law on the ground that Bendenberg, which is already held to be not applicable, is the basis of that judgment. Somewhat similar, my lord, which I would, my lord, if permitted, would wish to argue before the Supreme Court for Shreya Singhal. But I leave it at that. My lord, now chilling effect argument. Now, what has happened is, please appreciate, my lord, Twitter, by their own admission or by their own case before your lordship is that we are not having any speech. We do not have any expression. We do not have any view. We are only a platform. We offer a platform where others express their freedom of their views, opinions, expressions, etc. Lord, I am posing a question to myself, if that is their foundation in the petition, that I am only a platform, I am only a notice board, then how would they be able to invoke Article 19(1)(a)? It's not their freedom of speech and expression which is violated, though they brought somebody, my lord, as intervener, but he is an intervener, not a challenger. But, my lord, I am not, my lord, leaving it there. I can, my lord, say that therefore the 19(1)(a) is not available to them and therefore your lordships may not go into. But this is an opportunity where I would request your lordships to go into, while holding that they have no right. But please examine our validity of our law. But to come out of this argument, they say chilling effect. Now, chilling effect, my lord, is a word coined for a different purpose, but used at a drop of the hat when you have no other argument. And the chilling effect is this, that I am a platform, I give platform to others to express their ideas. If others know that my view is likely to be taken down under 3(1)(d), there would be a deterrent effect in them in
Kindly excuse me for
in posting something. So Tushar Mehta will be afraid of posting on the ground that government may inform Twitter that this is unlawful under 3(1)(d).
That's the chilling effect.
That's chilling effect on me. And
Yes.
therefore, they are representing those who are being chilled by 3(1)(d).
Who would upload?
To
into the-
upload.
Upload, yes.
My lord, first, Lord, this chilling effect is now dealt with by a 3-judge bench. Shreya Singhal is a 2-judge bench judgment. After referring to Shreya Singhal, after referring to the chilling effect, my lord, I had an occasion to, my lord, assist the court in this judgment. Anuradha Bhasin, my lord, which was an internet ban in Jammu
Yes,
and Kashmir.
Jammu and Kashmir.
Please have a look at, my lord, only one paragraph. It's a 3-judge bench judgment, my lord,
Yes.
at the cost of repeating. The widening of the chilling effect doctrine has always been viewed with judicial skepticism. At this juncture, we may note the decision in Larid versus Statham, that is US Supreme Court, wherein the respondents brought an action against the authorities to injunct them from conducting surveillance of lawful and peaceful civilian political activity based on the chilling effect doctrine. The United States Supreme Court, in its majority decision, dismissed the plea of the respondent on the ground of lack of evidence to establish such a claim. That chilling effect must not be pleaded, that there is a probable, there is a hypothetical chilling effect. Supreme Court of United States says allegations of a subjective chill are not an adequate substitute for a claim of specific present objective harm or a threat of specific future harm. Now our court says, my lord, in Anuradha Bhasin.
Yes.
Therefore, to say that the aforesaid restrictions were unconstitutional because it has a chilling effect on the freedom of press generally is to say virtually nothing at all, or is saying something that is purely speculative unless evidence is brought before the court to enable it to give a clear finding which has not been placed. That this is how there is a chilling effect. There were 100 people who wanted to upload, but they said we are not uploading because we are afraid. Thereafter, my lord, the court goes on, my lord, to analyze how in that case, for example, Anuradha Bhasin was, my lord, owner and editor of one newspaper. So she said internet ban has a chilling effect, etc., etc. The court said that you have not even given people similarly situated like you are also equally chilled. There are several newspapers published from Jammu and Kashmir. Even that is not done. So chilling effect is not, my lord, an all-in-all solution in 19(1)(a) rights, my lord. My lord, then, my lord, Larid versus Statham, my lord, which is cited by our court, my lord, with and accepted. Lord, please have a look at page 68, and this is the last decision on this subject, my lord.
Yes.
I will not trouble
Yes,
your
sir,
lordship
yes.
further. My lord, it's quoted, I will not read it, my lord. I can go, my lord, further. My lord, rest of the judgments are on the same line, and therefore I am not, my lord, reading. Kindly directly come to page 74. My lord, I have said that in Cricket Association of Bengal, I would wish to assist your lordships with the minority, not minority, concurring view of Justice B.P. Jivan Reddy. It's a concurring view. So it is equally, my lord, I will not say binding, my lord, but it is equally having the force of law under Article 141. My lord, in majority, I have read, my lord, when I
Yes.
read Cricket Association,
Yes.
but this is concurring view of Justice B.P. Jivan Reddy.
Concurring view always goes with the majority view.
Yes,
It is always to be read along with the majority.
it's a majority.
Yes, it's
It
a
is a
different-
law of the land. Concurrence is always a law
Yes.
of the land. And it has a binding effect.
Yes.
Because sometimes the honorable judges concur on a different point.
Yes.
They come to a same conclusion, but with
On different
another
reasons.
route, another
Different
argument.
reasons.
Even those arguments
Yes.
which are accepted is a binding law under 141. Kindly have a look at, my lord. This is, my lord, really illuminating judgment, my lord. Page 70,
5.
no, my lord, not 75, page 78,
Yes, sir.
para 187.
Yes.
This is really, my lord, illuminating view, and you may assist your lordships, my lord, subject
Yes,
to your
yes.
lordships, my lord, being persuaded. A look at the grounds in clause 2 of Article 19, in the interest of which a law can be made placing reasonable restrictions upon the freedom of speech and expression, goes to show that they are all conceived in the national interest as well as in the interest of the society. This was television and freedom of expression under 19(1)(a) being curtailed in the medium of television. Kindly bear that in mind, because the court said that medium is different and different medium makes the different when we evaluate 19(1). The first question of grounds, that is the sovereignty and integrity of India, the security of the state, friendly relations with foreign state and public order are grounds referable to national interest, whereas the second set of grounds, that is decency, morality, contempt of court, defamation and incitement to offense, are conceived in the interest of the society. The interconnection and the interdependence of freedom of speech and the stability of society is undeniable. They indeed contribute to and promote each other. Freedom of speech and expression in a democracy ensures that the change desired by the people, whether in political, economic, or social sphere, is brought about peacefully and through law. That change desired by the people can be brought about in an orderly, legal, and peaceful manner is by itself an assurance of stability and an insurance against violent upheavals, which are the hallmark of societies ruled by dictatorships, which do not permit this freedom. Lord, kindly come to 188.
Yes.
It is for this reason that our founding fathers, while guaranteeing the freedom of speech and expression, provided simultaneously that the said right cannot be so exercised so as to endanger the interest of the nation or the interest of the society. Lord, now it's not just public order, it can be even interest of the society, as the case may be. This is not merely in the interest of nation and society, but equally in the interest of freedom of speech and expression itself. The reason being the mutual relevance and interdependence aforesaid. Reference may also be made in this connection to the decision of US Supreme Court in so and so, referred to herein above, wherein it has been held that to deny a station license because the public interest requires it to be, it is not a denial of free speech. It is significant that this was so said with reference to First Amendment to United States Constitution, which guarantees the freedom of speech and expression in absolute terms. Your lordships are aware. There are nothing like 19(2). There, those freedoms are absolute. No reasonable restrictions conceived or contemplated in United States. The reason is obvious. The right cannot rise above the national interest and the interest of society, which is but another name for interest of general public. It is true that 19(2) does not use the word national interest, interest of society, or public interest, but as pointed out herein above, the several grounds mentioned in clause 2 are ultimately referable to interest of the nation and of the society. So now the elasticity, I'm sorry,
Yes.
the elasticity in the heads under 19.2, which was conceived in the First Amendment, is applied. That it is not static. In the interest of means it falls, brings within its sweep several things, and it will have to be widely construed. Now, please come to, my lord, page 81. My lord, Puttu Swami judgment.
Huh.
I'm sorry, my lord, the judgment, this very judgment, but last part, my lord.
Yes, para 199.
199.
Yes.
All the constitutional courts whose opinions have been referred to herein above, herein before, have taken the uniform view that in the interest of ensuring plurality of opinions, views, ideas, and ideologies, the broadcasting media cannot be allowed to be under the monopoly of anyone, be it monopoly of government or of individual, etc., etc. Only, my lord, highlighted part. This again is the implicit command of Article 19(1)(a). This medium should promote the public interest by providing information, knowledge, and entertainment of good quality in a balanced. Now, my lord, Puttu Swami, it is, my lord, customary to cite in every case, whether, my lord,
Right to
when you want to
privacy,
show that you are a great constitutional lawyer, my lord, in every case, you start with either earlier Keshwanand Bharti and now Puttu
Now
Swami.
Puttu
I'm not, my lord, citing Puttu Swami. Your lordships are, my lord, aware of it.
Yes,
My lord, but I am reading, my lord, Kaushal Kishore.
Yes.
It's a constitution bench. But I always avoid citing Puttu Swami unless it is really on the point. But otherwise, in all constitutional benches I have seen, or even in regular court, regular matters, some of our constitutional experts, they start with earlier Keshwanand Bharti, and now they have Puttu Swami. I see Golaknath. Yes, yes,
Golaknath.
it starts with Golaknath and Shankari Prasad and everything, and then
No, now the advocate on record's favorite judgment is this. Puttu Swami.
Puttu Swami.
For everything he comes up with that.
Must be from NLU. I have seen, my lord, all NLU grades. They are brilliant people.
Yes,
My lord,
yes.
they are much more informed, much more focused. My lord, this generation is definitely much
Oh,
better
yes.
than our generation.
Yes,
But,
yes.
my lord, they are taught to be constitutional lawyers and not lawyers. So they start with, my lord.
And the challenge for lawyers like us, my lord, is to keep pace with them.
Yes, well, yes, my lord, it's a challenge. My lord, now Kaushal Kishore, my lord, again a concurring opinion.
Yes.
Please see, my lord. Per contra, in respect of speech and expression which constitutes an exchange of ideas, including dissent or disagreement, and such ideas are expressed in a manner compatible with the ethos cultivated in a civilized society, the duty of the state to abstain from interference is high. Similar, my lord, then para 193.4. It is evident from the above illustrations, the extent of protection of speech would depend on whether such speech would constitute a propagation of ideas or would have any social value. If the answer to the said question is in the affirmative, such speech would be protected under Article 19(1)(a). If the answer is in the negative, such speech would be protected under Article 9, would not be protected under Article 19(1)(a). In respect of speech that does not form the content of Article 19(1)(a), the state has no duty to abstain from interference having regard to Article 19(2) of the Constitution and only the grounds mentioned therein. So, my lord, unlawful thing is not a speech at all. So, there is no question of, my lord, curtailing it.
Every
So, then your
citizen
lordships can, my lord, read it, my lord. Now, my lord, history of safe harbor provisions. I'll very briefly, my lord, I'll not take your lordships through.
Well, every citizen of India must consciously.
My lord, there are two
restrain in
judgments which
speech.
we found yesterday.
Yes.
Therefore, they say, my lord, never give overnight to a lawyer, my lord, and he comes out with something new. But this only says that reasonable restriction is elastic and dynamic and must meet with the demands of time. It's not static. That public order means something should happen in some area that people should start rioting. That's not the case, my lord. My lord, there are 6 judgments. My lord, there are 6 judgments. I'm not going to read any of them.
Yes.
And I have, my lord, relevant paragraphs. I will give it to your lordships because some judgments are very lengthy.
Yes.
And, my lord, I will, my lord, along with this, my lord,
Yes.
I'll give the relevant paragraphs. So
That is not there.
your lordships,
That- yes.
well, I have the Xerox copy.
Yes.
It says, my lord, reasonable restrictions should be elastic. My lord, very fundamentally, Why would the constitution use the word reasonable restrictions? Why would it not say that restrictions? The word existence of the word restriction would itself mean that there is an elasticity given to the parliament that you can decide the reasonableness depending upon the menace or situation you are dealing with, and according to the reasonableness conceived by the parliament, of course subject to judicial review, you can mold the section. So it's not that public order means public order. It should be reasonably construed, elastically construed, and it will have to be construed to achieve the object which it seeks to achieve. Well, these are the well, 6 judgments, and I'm not
I'll look into it.
reading.
All on,
The point is, if rights are dynamic, even the restrictions will have to be dynamic. For example, Article 21A initially was read in the static sense. It was, my lord, adopted from Japan verbatim. In Japan also that is being, my lord, evolved. India also it is evolved. Now everything is covered: right to dignity, right to bodily integrity, right to food, right to education, right to environment, everything. If right can expand, so will have to the restrictions with reasonableness. So when we say 19(1)(a), 19(2) also will have to have that expansive meaning.
so the submission is that they go hand in hand.
Yes, they will have to.
Have to.
Right and duty go in hand in hand.
Yes.
Right and reasonableness of restriction
Also go hand in
will have to go in. It cannot be argued that 19(1)(a) will continue to expand, but 19(2) will be
Restrictions will not.
static.
Then it will lose its dynamism.
Dynamism. That constitution becomes static, not a living document. Now, my lord, next point, and I'll not, my lord, trouble your lordships in detail. I'll just broadly say why I have put this, my lord. My lord, we researched on this, my lord, that in print media there was no safe harbor. There was a strict liability. Strict liability means you are responsible. In electronic media also there was none, and there is none. There is no there is no protection. Lord, when internet started evolving, several electronic related issues started cropping up. The first judgment which came, which I'll not read, I have cited it, my lord, was with respect to somebody posting my lord, something which was protected under the Copyright Act.
Copyright.
It was, my lord, some Playboy images were,
Yes.
my lord, posted in a intermediary called Bulletin Board Systems, BBC. One Frenna was the owner.
Yes.
He said that I have physically checked everything and I have thereafter removed it. How am I responsible? But that was a regime of strict liability, and therefore he was held liable that because it is on your platform, you are responsible. I'm not reading it, my lord. Strict liability principle was evolved. Now, my lord, evolution was that all intermediaries around the world in their respective governments, respective parliaments, etc., they started making a representation that, look, our medium is different. We are only providing a platform, and rightly so. They are only providing a platform. They are manipulating or curating the content, that apart. But their basic job is to provide a platform.
The platform, yes.
So they said that let us have a midway approach. Don't make us responsible with strict liability that because something is posted or hosted in my platform, I am responsible. Make it conditional, and this is important, make it conditional upon my actual knowledge and still not acting. That was a very sensible middle way. That if somebody informs me that there is something unlawful which is capable of being challenged before the court, and I don't do anything, then I am responsible. Otherwise, I have lakhs and crores and millions of posts, I cannot check. Though they do check. There are algorithms available. There is a check available. There are filters available. But they choose not to filter certain things if they are getting more hits. And I'm not saying about only Twitter. This is true about any intermediary where, my lord, their revenue model is built upon more hits and therefore more generation of. So, my lord, now, my lord, for the first time, the United States Supreme Court at page 90.
That's an Clinton administration.
Yeah, yes, my lord.
1993.
93, my lord, yes, came out that all right, this middle way.
Strict
That
liability.
no strict liability, but if you are informed and you have the actual knowledge, then you are liable. If you are not aware, then you are not liable. That was a midway. So it was on their request, the intermediaries' request, that actual knowledge will hold us liable. That this entire regime was developed. Now please come to page 90. I'm not reading it, but this is, my lord, section 230 of the Communications Decency Act, where your lordships would find at page 91, protection for good Samaritan blocking and screening of offensive material. That is the head, and they were exempted because somebody has informed you. And this was, please mind, remember, this was an era where even a private person can inform.
Yes, yes.
Actual knowledge was necessary, which is now, my lord,
Interpreted. to be the court's
interpreted that
direction.
actual knowledge means court order, not a private individual. Now, my lord, please come to page 93, para 179. Lord, this would be relevant because other jurisdictions have also followed, my lord, this. Thus, from the above discussion, it can be seen that that though initially intermediaries were made strictly liable for any unlawful material available on their platform, but sensing advantages of internet in the field of educational, e-commerce and informational resources, and considering high utility of intermediaries in providing a forum for true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity, they were provided with an immunity or safe harbor, provided they observed the scheme of taking down the unlawful material available on their platform upon receiving the actual knowledge of it. And this principle, that no complete strict liability, no exemption which is complete, there would be no strict liability. If you are informed and you do not nothing, then strict liability. If you are informed and you take steps or choose not to take steps, then, Lord, please come to page 94. Lord, this is,
Yes.
Lord, US Congress, page 94, principle 6 and unnumbered paragraph 3. The title is Limited Liability of Service Providers for Internet Content. Subparagraph 3.
Yes.
In cases where the functions of the service provider are wider and they store content emanating from other parties, member states may hold them co-responsible if they do not act expeditiously to remove or disable access to information or services as soon as they become aware, as defined by national law, of their illegal nature in the event of claim for damages of facts or circumstances revealing the illegality of the activity or information.
Yes.
So protect them if they are not aware. Then, my lord, rest I may not read. Please come to page 97. How, my lord, notice is to be given on actual knowledge. Lord, as per the US provision.
Yes.
Lord, I'm not reading it, but there is a provision how, my lord, they were given notices. Now, my lord, difficult. Now the position is this: intermediaries rightly came before all respective governments of the countries globally that our nature of the medium is different, and therefore we need some kind of a protection. At the same time, the government interest is also to ensure that we do not host anything which is unlawful. So, middle path which was found globally was that if you are informed and if you do not do anything, then you are not risk. Now what happened, my lord? Having got that safe harbor, now 79 is what? 79(1) says you are protected for any third party information, subject to 1 and 2,
Yes.
Subject to 2 and 3, and 2 and 3 in substance says that if you are informed, if you do not follow the guideline, then 1 will be lost. Subsection 1 harbor will be lost. First, they tried to challenge 79, 2 and 3 before the Supreme Court. Supreme Court did not interfere.
Yes.
Your lordships have
Yes,
seen.
yes.
Merely read it down to mean that actual knowledge means not from private parties,
From the court.
from the court, but government's power of notifying about the unlawfulness was retained, though, my lord, that was not presented before your lordships. Now, my lord, a step further, that now even the guidelines under 2, which are, my lord, guidelines for the purpose of, what is the word used? Due diligence, that is also required to be set aside, because though I have no freedom of speech and expression, it's not my right. but there would be a chilling effect. What is the material? What is the chilling effect? It's a speculation. It's a presumption. It's a probability of chilling effect. To what extent, to how many persons, in what subject, what genre. And in some genres, for example, pornography, if there is a chilling effect, it should be chilling. It is intended. Now, your lordships may kindly turn to page 100, and I'm not going to read this, but
Yes.
your lordships may get substantial assistance, my lord, from
Of all the, on different regimes.
on different regimes. My lord, kindly only see the title, the country, the safe harbor regime, what is equivalent to 79.
Yes.
Then similarity to India's safe harbor regime.
Yes.
We have compared other countries' safe harbor regime with 79. And last is status of compliance by intermediaries. My learned friend would say, my lord, that last column is a statement of fact.
Yes.
But my lord, this is what we have gathered from. But my lord, interesting part is in United States, except sharing the algorithms, every social media intermediary, they are by and large compliant, including my lord, X. So wherever the government wants to implement, they are okay with it. But in
Algorithms,
India,
they-
they have problems, my lord, constitutional challenges, this, that. Not they means only, my lord,
Intermediates.
all intermediates.
Yeah, all
my lord. I'm
intermediates.
not on X or something. Well, the difficulty is, my lord, I find it, my lord, really amusing. They say Article 14. Article 14 is arbitrariness. Well, definitely, doubtlessly, admittedly, this company is American company. The office bearers are also sitting in America.
Yes. Yes.
Lord, can my company of my country go to US and file a petition saying that the government policy is arbitrary?
Yes.
I leave it at that.
Yes.
Why not?
But another, you don't have locus, you will be thrown out on locus. Even X is thrown out on locus by this honorable. And considering their conduct, I have quoted that. Considering the conduct of X, Lord, the cost of 50 lakhs is imposed, which is reduced by the division men to 25 lakhs. But I am not, my lord, on that. Lord, then, my lord, there was a argument that 69A and 79 are overlapped. So that argument is inherently wrong on two grounds. 69A is a penal provision. 79A merely puts them to caution that if this is not done, maybe your safe harbor will be lost. You may have to face civil or criminal consequences. Second, Lord, my learned friend, my lord, pointed out a chart. What are the grounds available under 69A and what are the grounds available under
79.
79? Look, there are more grounds available under the 79. Look, there are several instances in the real life of internet usage which the nation or the government comes across which may not fall strictly either under section 69A or they are of such a nature that the harshest step of blocking it under 69A may perhaps be disproportionate. For example, my lord, as I have informed your lordships, my lord, and I don't think, my lord, I should show that, my lord, but we have created an AI-generated video.
Yes.
That your lordship sitting on this bench, in your lordship's voice, are saying something against the nation. It will not fall in any of the categories under 69. Nonetheless, it is unlawful. It's not even impersonation. Impersonation is my going somewhere and saying that I am Justice Nagaprasanna and I need some favor or some good treatment.
So this
That's no impersonation.
AI generated
Yes.
act which is unlawful straight away.
There are several acts which will not fall within 69A or they may not need the harshest treatment, my lord, which is the consequence. 69A is not just taking down. It's a criminal prosecution,
Yes,
2
yes,
years imprisonment.
yes, yes.
So, the legislative scheme is, there is a concept of least intrusive measures by the legislature. There may be harsh measures and there may be least intrusive measures. So, the legislature gives an option of least intrusive measure. Don't ask them, don't block them, don't criminally prosecute them.
Caution
Just
them.
caution them that you can continue, take your business call,
But this is unlawful.
but this is unlawful according to us. You can say it is lawful. But then safe harbor will not be available. When the court of this country is approached by a citizen of this country, you will not be able to say that I can't be touched because of 79, because you are in breach of 79, 2 and 3. Then you will have to defend, you may succeed also. The court may say that no, government was wrong. It is perfectly lawful. Suppose the government in a given case, my lord, gives a caution notice to them, which they take, my lord, a considered view that no, this is not unlawful, we would continue. It's a freedom of speech and expression. They may succeed. My lord, then, my lord, so the distinction, my lord, I have pointed out.
Yes.
Page 113, my lord, I have given what is the purpose, standard and consequences of 69A. I'm not troubling your lordships with
Yes.
that, my lord. I have given, my lord, everything. My lord, then 79, my lord, I have given competing rights.
Yes.
My lord, the honorable courts have developed a theory that each fundamental right do not exist or operate in separate silos.
Yes.
My fundamental right to do something might come in conflict with my learned senior's fundamental right of my not doing it. Suppose my fundamental right of free speech and expression might hamper his right of privacy, his right of dignity, if I say something which is undignified. So there is always competing fundamental rights, 14, 19, 21, other rights, etc. And therefore, a jurisprudence is developed, which I am, Lord, very respectfully relying upon, that you will have to balance the competing fundamental rights to achieve the constitutional goal. And that is what, my lord, I am citing only one judgment of Subramaniam Swamy, where he challenged, my lord, 499 and 500, the definition of defamation. Where, my lord, this law was discussed in detail.
There, for the first time, impact doctrine was.
Yeah, yes, I'm great. I'm great. My lord, please come to page 117. 117. My lord, this is a judgment post Shreya Singhal.
Yes, yes.
So Shreya Singhal did not have the advantage of assistance of this judgment, my lord.
Yes.
Lord, be that as it may, the aforesaid authorities clearly lay down that the freedom of speech and expression is a highly treasured value under the Constitution, and voice of dissent or disagreement has to be respected and regarded and not to be scuttled as unpalatable criticism. Emphasis has been laid on the fact that dissonant and discordant expressions are to be treated as viewpoints with objectivity, and such expression of views and ideas being necessary for growth of democracy are to be zealously protected. Notwithstanding the expansive and sweeping ambit of freedom of speech, as all rights, right to freedom of speech and expression is not absolute. It is subject to imposition of reasonable restrictions. Then, my lord, what is reasonable restriction? Chintaman Rao, my lord, one of the leading
Yes.
judgment is considered, your lordships are aware. Lord, kindly come to the next, my lord. I have made bold, my lord, the same thing, my lord, which my lords were pleased to indicate, para 130, only bold part.
Yes.
The impact doctrine or the principle of inevitable effect or inevitable consequence stands in contradistinction to abuse or misuse of a legislation or a statutory provision depending upon the circumstances of the case. The prevailing conditions of the time and the principles of proportionality of restraint are to be kept in mind by the court while adjudging the constitutionality of a provision, regard being had to the nature of the right. Look, this is least intrusive. Proportionately, this is the minimum we could have done. That is 3(1)(d).
Yes.
Then, my lord, 137, the bold part.
Yes.
One fundamental right of a person may have to coexist in harmony with the exercise of another fundamental right by others, and also with reasonable and valid exercise of power by the state in light of the directive principles in the interest of social welfare as a whole. The country's duty is to strike a balance between competing claims of different interests. My lord, thereafter, my lord, the same is followed in Sahara, India.
Yes, yes.
My lord, I am not reading, but kindly, my lord, treat it as read so that your
Yes.
lordships get, my lord. But
No, I'll
please
go
come
through
to
it.
page 122. Lord, this is something, my lord, I found that I may, my lord, even at the cost of repetition, your lordship must have read several times. I must, my lord, place for your lordship's consideration. My apologies.
No, no.
195.
Yes.
Somewhere, my lord, 5 or 6 line from the top. Thus, we are unable to accept.
Yes.
Does your
Yes.
lordship get?
Yes.
That provisions relating to criminal defamation are not saved by doctrine of proportionality because it determines a limit which is not impermissible within the criteria of reasonable restriction. It has been held in this is Saxena versus so-and-so, though in a different context, that if maintenance of democracy is the foundation for free speech, society equally is entitled to regulate freedom of speech or expression by democratic action. The reason is obvious, that is, that society accepts free speech and expression and also puts limits on the rights of the majority. Interest of the people involved in the acts of expression should be looked at not only from the perspective of the speaker, but also the place at which he speaks, the scenario, the audience, the reaction of the publication, the purpose of the speech, and the place and forum in which the citizen exercises his freedom of speech and expression. The court had further observed that the state has legitimate interest, therefore, to regulate the freedom of speech and expression, which liberty represents the limits of the duty of restraint on speech or expression, not to utter defamatory or libelous speech or expression. There is a correlative duty not to interfere with the liberties of others. Each is entitled to dignity of person and of the reputation. Nobody has a right to denigrate others' right to person or reputation. There is a distinction between social interest and a nation of and the notion of the majority. The legislature has exercised the legislative wisdom, and it is inappropriate to say that it expresses the notion of the majority. They said that what is parliament? Ultimately, majority has said something. They said no, it is reflecting the will of the people and therefore should not be interfered very loosely. Now, my lord, I'll just give the headings of my note and I'll not read it. I know, my lord, it would be too naive on my part to read it before this bench. So therefore, Rule 3(1)(d) is constitutionally sound. My lord, I have given the reasons. My lord, my learned friend relied upon Kunal Kamra. My lord, I'll just take 5 minutes on that.
Fact check.
What was that, my lord? My lord, I'll just, my lord, give an example. Suppose I tweet that from Monday onwards, the Prime Minister is going to declare what was that? Corona lockdown, which is completely wrong. Suppose somebody were to tweet that from Monday onwards, the Chief Minister of Karnataka is going to distribute 20 kg of rice and 20 kg of pulse per person from the fair price shops. There would be a huge queue, etc., etc. Now, what is the remedy with the government? We don't want to curtail anybody's freedom of speech and expression. So we created a fact check unit. It would check such facts either on its own or being brought to the notice. The consequence was interesting, which, my lord, of course, unfortunately did not find favor. The consequence was that if it is Twitter or a Facebook, we will intimate them that this is fake.
Actually wrong.
Factually wrong. This is fake. You need not take down. You just mention at the foot that according to the government, this is not factually. Just, my lord, a disclaimer. It doesn't hamper anybody's freedom of speech and expression. You can say that from tomorrow onwards, this is going to happen, which is completely imaginary. Don't take it down, but put it. But that, my lord, was also, my lord, found to be, at least by 2 judges, 1 judge, my lord. But I'm not, my lord, going into that debate or discussion.
That's 3(1)(b)(5).
Yes, my lord. So, my lord, it is completely on a different fact situation. It was a fact check unit. Here, my lord, there is a statutory regulation in place where we are using the least restrictive method of just cautioning them. Then, my lord, another head is 3(1)(d) is a valid exercise of the power of delegated legislation.
Yes.
My lord, I am not reading it.
Yes.
Then suitably tailored with adequate safeguards. Now, please see this, my lord, 239. This may be relevant. It's
Yes.
not, my lord, an arbitrary provision that we intimate them and expose them to litigation, etc. There is a methodology. My lord, this is a method, my lord, where both of us will have to cooperate with each other. They are also ultimately, my lord, as my lord, in Facebook case of Supreme Court, my lord, Ajit Mohan, the Supreme Court says that very candidly and very, my lord, boldly, that India is marketplace for all of by sheer population. So you can't ignore us. So better you follow the laws of the land. And law of the land merely tells you that we are cautioning you. You engage with us if you have any problem. And this is, my lord, the procedure which is contempt. The process of removing or disabling access to unlawful information on the Sahyog portal will involve the following steps. Now, what is Sahyog portal? I'll just broadly say. I don't think my learned friend also, this is my presumption, not to dilute his submission. He was very serious. But what happens is, if your lordships have seen the scheme of 79 and the rules, Lord, they receive the intermediaries, it can be any intermediary, they receive a notice from, they are supposed to receive a notice from an authorized government agent. Now, they do not know who is authorized across the country. Pardon?
Engineer of the metro.
That's
Yes, he is an authorized representative. I'm
under
not
the
apologetic about it. He is a designated authority because railways has a potential of great public disorder. So it's not a matter of laughing that a railway engineer is a designated authority. I'm not apologetic about it. There are several people. It's not necessary that only police people are supposed to be designated authorities. There are several departments where
the act permits anybody to be made designated
the
authority.
difficulty is this kind of, my lord, 3-1D situations arise in, say, consumer affairs department. It may arise in finance ministry.
There should be some
railway
authority
ministry.
to
So some authority will have
issue
to
a
be,
notice to take down.
Lord, some authority will have to be designated in each ministry at each level. Lord, what used to happen was that anybody used to write a letter. Some police station in Kolkata or some police station in Bombay would send a letter to, say, Facebook that delete this, there is a criminal action, it's very serious, and you take it down. Now, they did not know that this is authorized or not authorized. Now, even if, my lord, my designated authority is authorized, I would have I had no means of knowing whether, what is their response, whether they have complied with or they have, suppose it's a 69A order, they have to comply with,
Yes.
there is no choice. If it is a 3-1D order, they have to take a call not to obey or not to comply or to comply. So compliance was not known to us. The intermediaries therefore came to the government.
One portal.
That you have a portal where if it is uploaded on that portal,
Compliance will also be uploaded.
now we would know, the intermediaries would know that the person who is authorized has issued this notice.
Yes.
And somebody, not somebody. And the government will also know about the compliance.
Compliance.
So it is merely an administrative mechanism for smooth of governmental business and business of the intermediaries. And Twitter is not even, has chosen not to join that portal. Rest of them have joined the portal. Portal is working.
So it is a portal for implementation in harmony.
Harmony and in the interest of the intermediaries, that a person who is not authorized may not engage with them. And they come to know from an authorized source that this direction or a request or a caution is coming from a person who is statutorily authorized. And instead of receiving 10 notices from all across the country, you get it only at one place. You have to open only one site daily and you know that there is something which is sent to me. So it is, my lord, an administrative convenience. This is called ease of doing business by the government business, by the intermediaries, their business. I don't see, my lord, what objection can there be? They say there is no statutory backing. There need not be. There are several things, my lord, which we do. There is no statutory backing. My lord, we have, my lord, for example, a website for the grid, my lord, this litigation, etc. There is no law. Data grid. It's an administrative decision just for ease of doing business that anybody can click, anybody can go on that site and find out what the position is. You don't need statutory backing or some source of power through a parliamentary law or a legislative law to create something administratively for smooth functioning of the government. That is all. Now please see, my lord, how the process works. In 69A and 3-1.
Yes.
69A has separate rules, my lord,
Yes.
because of the harsh consequences.
Yes.
This is penal in nature, etc. The process of removing or disabling access to unlawful information on the Sahyog portal will involve the following steps. The nodal officers of authorized agency issue notices through the portal to the intermediaries. On receipt of notices, the intermediaries will respond to the notices and inform the action taken. The intermediaries can remove or disable the unlawful information. The intermediaries, if required, can seek additional information on the notices. The intermediaries can raise a request for non-compliance citing appropriate reasons. This is also optional. They need not give reasons also. If the authorized agency agrees with the reasons, the request will be closed. If the authorized agency disagrees with the intermediary's reasons for non-compliance, can record their further reasons and request for compliance. If the intermediaries comply with the request after further remarks, the request be closed. If the intermediary refuses compliance, there is a provision for issuing show cause notice to the intermediary for non-compliance. If the intermediary replies, the authorized agency may accept or not to accept the explanation. If accepted, the request will close. If not, the authorized agency may proceed to take action under Rule 7 of Information Technology, Intermediary Guidelines and Digital Media Rules. Please see that rule. That means your safe harbor goes, because 3 cannot be a toothless provision. It has to have some consequence.
Yes.
Therefore, Rule 7, which is not in challenge, says that if you do not follow Rule 3, then your safe harbor goes. Then, my lord, page 129, 31D does not contravene the principles of separation of power. My lord, this argument, my lord, may not, my lord, invest your lordship's time much, my lord. There is nothing like separation of power, my lord. Yes. When we are dealing with an intermediary, which is a defined term under the statute, my lord, it's not that every time the government will have to go and get a judgment from the court whether this is unlawful or not. Particularly in context of the very nature of this medium, where virality is the key. You have to act swiftly as a government. So you cannot say that you have to wait till some court decides.
No, that's what I was asking. If a post is made again derogatory to some person and you have to go to the rigmarole of all procedure, the post damage is done.
My lord, suppose, my lord, there is a post.
That is why, my lord, we have Rule 8. That is why we have in 69A.
In
It is
2011.
There are many things.
So
which,
it is not as if it is remediless.
No, that's what I asked and held.
That's all right.
Lord, only a
I
minute.
just want to
Only a
clarify
minute,
that
my lord,
position.
give me a minute. I'll show 2 posts.
Just one.
And I'll request my learned friend to tell
And
me.
at 239, which was relied upon, is a submission that is being made before your lordships. It is not in the rules. None of what has been stated in para 239 is found in the statute.
We'll make a note of it.
Please ignore it, my lords. Well, I don't want to join issues on that. My lord,
Yes,
because,
yes.
my lord, I'll just show, my lord.
No, I just start, when they were arguing, I just asked, saying if you have to follow the rigmarole of entire procedure, then the damage is done by the post being on that platform for all time.
That is why
And Rule 8 is
But
what
now
was
in
said.
this context, my lord, Shreya Singhal rejects my argument about the medium. Thereafter, I have shown, my lord, the evolution of law based upon the internet as a medium, and particularly with reference to social media intermediaries. Lord, please allow me to show one paragraph from Shreya Singhal, my lord.
Yes, sir.
My lord, I had cited this, my lord. Difference between mediums.
So sorry to digress, but
It is in the judgment.
I thought what I asked.
I quote verbatim this one.
No, sorry to digress the arguments.
No, absolutely not, my lord. I'm on almost at the end, my lord.
Yes, yes.
And I will be, my lord, page 830, Shreya Singhal, my lord.
Yes.
Now, my lord, this will have a fresh look, these arguments, in view of the law which has evolved from Shreya Singhal onwards,
That's
even
your,
in the United States.
that's your submissions.
Yes, and the court records, court says this, my lord. It was argued by the learned additional solicitor general that a relaxed standard of reasonableness of restriction should apply, regard being had to the fact that the medium of speech, being the internet, differs from other mediums on several grounds. To appreciate the width and scope of this submission, we are setting out his submissions, written submissions verbatim.
But-
In the context of Reno, the court had only Reno in mind.
Yes.
The breach of print media is restricted to one state or at the most one country, while internet has no boundaries and its reach is global. The recipient of free speech and expression used in a print media can only be literate persons, while internet can be accessed by literate and illiterate both, since one click is needed to download an objectionable post or a video. In case of television serials, except live shows and movies, there is a pre-permitted, I'm sorry, your Lordship.
Pre-censorship, yes.
Pre-censorship, which ensures right of viewers not to receive any information which is dangerous to or not in conformity with social interest. While in case of internet, no such pre-censorship, we are not seeking pre-censorship, is possible. I'm just saying what is the difference between the mediums, and each individual is publisher, printer, producer, director and broadcaster. I can make my own reel in whatever manner I want and I can upload it. I am the producer, I am the director,
Yes,
I am
sir.
the hero, I am the script writer, I am everything. Similarly, I can create a magazine, and there are many magazines which are running like. By the medium of internet, rumors having a serious potential of creating a serious social disorder can be spread to trillions of people without any check, which is not possible in case of other mediums. In case of mediums like print media, television and films, it is broadly not possible to invade privacy of unwilling persons. While in case of an internet, it is very easy to invade upon the privacy of any individual and thereby violating his right under Article 21. By its very nature, in the mediums like newspaper, magazine, television or a movie, it is not possible to sexually harass someone, outrage the modesty of anyone, use unacceptable filthy language and evoke communal frenzy which would lead to serious social disorder, while in case of an internet, it is easily possible to do so by mere click of a button without any geographical limitation, and almost in all cases while ensuring anonymity of the offender. I can open my account, I'll show. We have opened one account in the name of Supreme Court of Karnataka, and Twitter has opened that account, and it is a verified account by Twitter. Supreme Court of Karnataka. Now I can post anything in that, and lakhs and lakhs of people who view that will say Supreme Court of Karnataka has said. Therefore, I say anonymity. I can remain anonymous or pseudonymous, and I'll show that. This is the Twitter page of Supreme Court of Karnataka, which is verified by Twitter. Just to show, we have not used it because otherwise it comes in public domain.
Yes, yes.
We have not used it. We have not sent any
Created
message
it.
from this. This is just to show that there exists an account, and within 5 minutes.
I have objection to this, my lord, because this is not to be put against me without even being put on record. So that I can say, has it gone through my scrutiny process? What is the extent of scrutiny I can do? This, my lord, my learned friend was very fair when he
It's not
started.
circulated is what is said.
No, my lord, what
Sir, I can answer your
that
question.
cannot be done across the bar, passing on to your lordship.
No,
Don't
sir,
worry
sir,
about it.
only one
Be
thing.
done. And my learned friend was very fair when he said, I am not arguing on prejudice point, but I think, my lord, what is
No,
being
this
thought
is
to be
not
done
a
is only
prejudice
that.
point. This is the
Without even putting it on
extent of
record, I don't
damage.
have an opportunity.
No,
But it's
treat
not fair.
this as a Facebook account. I could have created a Facebook
What,
account.
my lord, whatever,
You
my
never
lord,
have been able to
I am
answer.
not on what is created, how it is created, who created it, and what is the role I have to play. I am only saying, let me, if it is to be relied upon as part even of a council submission, I am entitled, I think, my lord, I am right in saying that, to
Well,
have an art, how am I going to do it?
No, that is only an illustration. He.
My lord, that
I
illustration
am
may be.
giving an
that
Illustration,
may be wrong.
you can be rest assured those illustrations will not prejudice the mind. So,
No,
yes.
my lord, suppose I would have created a similar
I don't know, my lord.
Facebook account. Lord, I would have created a Facebook account in the name of Supreme Court of Karnataka. Would you have objected that I do not know how we verified, how was it verified, how was it registered? Lord, incidentally, it
No,
happened to be a
your
Twitter account.
submission is creation of such things in an intermediary is easy.
That's all, my lord.
That's the
It's very
submission.
easy.
That's
and
all the
that-
submission.
Nothing new, my lord, even with respect to the press. Your lordships will recall an incident. In fact, my lord, it happened in this court. And this court took suo motu cognizance and issued contempt.
2002.
Yes. The lord,
Anonymity, my lord, the point
Happens.
of law is.
Now, in that proton mail matter also, where he was
Yes.
he was not there, anonymity was the problem there.
Yes.
You shoot mails after mails which contain pornographic material to all and sundry of a particular organization, of those organization members. All are morph pictures. And it's so derogatory, so horrendous. The anonymity is claimed.
My lord, another problem, and I wanted to avoid
In fact,
arguing this.
anonymity was claimed even in that 2002 incident.
Correct. That
Where
is
my lord,
print
I
media.
don't know whether my learned friend knows.
I'm aware of proton.
Print-
That
print-
my
No,
lord
not
said.
proton, sir. I'm talking about the old incident that happened where it was
That's all
said.
right. Let's not take about that incident.
I respect,
Yes.
I
Lord,
respect.
as a matter of fact,
Yes.
my lord, why this debate will be academic? I'll tell your lordship the reason why. My lord, suppose there is a 69A order or non-compliance of 31D order. Prosecution, I'll lodge a prosecution if I am affected party. Lord, I'll prosecute whom? There is nobody in India.
Anonymity.
No, no.
No,
The
that's
Twitter
what-
has nobody in India. The people stay in
That's
America.
That's exactly what happened with
No, sir,
proton.
there's a chief technology officer in India,
So-
nominated.
So in case of non-compliance, he would be the accused.
I don't know. Depending upon the law.
My
That's all
learned
right.
friend, I thought very fairly gave the name that he represents Twitter. There is no.
No,
authorized-
when my learned, this is only to say, when my learned said there's nobody in India, no.
There is some
But
grievance.
representatives are
prosecuted,
there.
I don't know.
There is some grievance redressal officer, but there is no officer in the context of a criminal prosecution. And it's a foreign company, and everybody is
Yes,
in
it's
America.
foreign.
That's all. It's, my lord, now come to my lord 8. By the very nature of the medium, the width and reach of internet is manifold as against newspaper and films. The said mediums have inbuilt limitations. That is, a person will have to borrow a newspaper, and or will have to go to a theater to watch a movie. For television also, one needs at least a room where a television is placed and can only watch those channels which he has subscribed, and that too only at a time where it is being telecast. While in case of an internet, a person abusing the internet can commit an offense at any place at the time of his choice and maintaining his anonymity in almost all cases. In case of other mediums, it is impossible to maintain anonymity, as a result of which speech, idea, opinions, or films having serious potential of creating a social disorder never gets generated, since its origin is bound to be known. While in case of an internet, mostly its abuse take place under the garb of anonymity. In case of other mediums like newspapers, television, or films, the approach is always institutionalized approach governed by industry-specific ethical norms of self-conduct. Each newspaper, magazine, movie production house, or TV channel will have its own institutionalized policy in-house, which would generally obviate any possibility of the medium being abused. As against that, the use of internet is solely based upon individualistic approach of each individual who is using the internet, without any check, balance, or regulatory ethical norms for exercising freedom of speech and expression. In the era limited to print media and cinematograph, or even in case of publication through airwaves, the chances of abuse of freedom of expression was less due to inherent infrastructural and logistical constraints. In case of said mediums, it was almost impossible for an individual to create and publish an abusive content and make it available to trillions of people. Whereas the present internet age, the said infrastructural and logistical constraints have disappeared, as any individual using even a smart mobile phone or a portable computer device can create and publish abusive material on its own without seeking help of anyone else and make it available. Now, my lords, Lord, my last submission, my lord. Lord, my learned friend argued that what is contrary to law as used in 3(1)D is vague. I don't think, my lord, that needs, my lord, a specific answer, for the reason that what is either not permitted by law or what is prohibited by law covers it.
Yeah.
Beyond that, it need not be defined. But at page 130, I have given, my lord, one judgment where it says that some of the definitions are not capable of being defined. My lord, please see the bold portion only.
Yes.
At page 131, the impossibility of framing a definition with mathematical precision cannot either justify the use of vague expressions or the total failure to frame any definition at all, which can furnish by its inclusiveness, at least a safe guideline for understanding the meaning of the expression used by the legislature. But the point to note is that there are expressions which inherently comprehend such an infinite variety of situations that definitions, instead of lending to them a definite meaning, can only succeed either in robbing them of their intended amplitude. It's counterproductive to define it, or in making it necessary to frame further definitions of the terms defined, the defense of India, security of states, etc.
Under any law, time being in force. That is
Yes,
what
Lord.
3:1
And
says.
we have made it for retaining the amplitude. It is kept open-ended when anybody can understand that either prohibited by law or not permitted by law. That is against the law. My Lord, then no reading down, my Lord, is made out. And my Lord, please come to page 135. This is my last point, my Lord, and I'll stop.
Maintainability.
Yes, my Lord, when the government of India is before the constitutional court, we should not adopt a knee-jerk approach that decide the question of maintainability first. Then only we will answer on merits. Because it is the duty of the government, my Lord, as a representative of citizens, to satisfy the judicial conscience of the constitutional court or any court for that matter. And therefore, I addressed everything on merits. But now I come to a very fundamental objection, which I have as a preliminary objection, that X has no locus standi to file the present writ petition, my Lord, in under Article 226 of the Constitution of India. My Lord, at least claiming 19(1)(a) rights or 14 rights. My Lord, please come to, my Lord, page 135, ground A.
Yes.
That the writ jurisdiction of this honorable court has been invoked by the petitioner, which is an out and out foreign commercial entity. The affidavit to the present petition is sworn outside the territory of India by a foreign national who is purportedly acting on behalf of the petitioner. The petitioner has a mere status of intermediary as defined under the IT Act and no more. It is neither the citizen of India nor a natural person. Thus, the protection of Article 19, including right to disseminate information of speech or other citizens, or that of Article 14 and 21, is not available to it for the purpose of clothing it with locus to move the instant writ petition. It is for the individual citizens of the country to ventilate their fundamental rights before this honorable court. Petitioner being a mere foreign artificial juristic entity, both Article 32 and 226 are not available to it for the purpose of the present petition. My Lord, thereafter, my Lord, locus of the petitioner, your Lordships may only see, my Lord, page 138, para 269. My Lord, this honorable court has already dealt with their locus in a writ petition. And my Lord, please see 269, X Corporation versus Union of India. With a judgment dated 30th June 23, this honorable court clearly held that Article 19 and 21 are not available to the petitioner. It was held as under. Lord, I maintain Article 21 also would not apply to a juristic person, much less a foreign body. It is intended for individuals. A foreigner who is not a citizen of India is protected by 20. If he is a natural person, but not a juristic person. Lord, corporation by its very nature, right, 21 is right to life and liberty. Someone which can be wound up, even as per law, cannot claim right to life as a fundamental right. As simple as that. Petition has been structured, this is your lot, this court saying.
Yes.
Petition has been structured inter alia on the provisions of Article 14 of the Constitution as extensively construed by the apex court. Precedent by precedent, para 11, page 10 of petitioner's rejoinder reads, petitioner is canvassing rights under Article 14, 19 and 21 only to limited extent. Petitioner is mainly urging violation of statutory rights. Please pause here for a minute. Lord, this was the reason why they, while filing the petition, confined to statutory rights to make it maintainable. Thereafter, after my reply, they rightly found
Amended.
that unless they challenge the regulation rules, it would be difficult for them to maintain. Therefore, an amendment comes, and therefore Article 19, etc., my Lord, comes. Even otherwise, it cannot claim protection of Article 19(1)(a), because it is not a citizen. Then court quotes the judgment, and Article 21, because it is not a natural person. It also cannot espouse the arguable cause of Twitter account holders in absence of enabling provision of law, unlike trade unions espousing the cause of workmen under the provisions of the Trade Union Act and Industrial Disputes Act. It is submitted, however, this Honorable Court held that said petition is maintainable in view of the fact that Article 226 also allows ventilating statutory rights, and since petitioner was ventilating statutory rights, the petition is maintainable. Here, argument after argument was based on fundamental rights, constitutional rights. Now, please see, the petitioner company is not only threatened of losing its protection available under Section 79(1), but also penal action for violation of mandatory provisions of the Act and website blocking rules. In view of the above discussion, this court is of the considered view that petitioner has locus standi to tap the writ jurisdiction of this court for the redressal of its arguable grievance, but not challenging the rule. After holding the said petition to be maintainable, the Honorable Court analyzed the conduct of the petitioner, which clearly evinced non-compliance by the petitioner and therefore declined to entertain the petition. Maintainability is different, and your lordship's discretion to entertain it is different. The non-compliance with Section 69A orders has the potential to make the tweet more viral and spread to other platforms as well. One can imagine the damage potential when such objectionable tweets are allowed to be disseminated despite interdiction. The damage potential is directly proportional to the delay brooked in the compliance of such orders. Petitioner has demonstrably adopted a tactical approach to delay compliance, and that shows its intent to remain non-compliant to Indian law. No plausible explanation is offered for the delay in approaching the Constitutional Court either. Petitioner has abruptly complied with Section 69A orders a bit before coming to court, though second respondent had issued compliance requirement notice way back on so-and-so threatening. It needs to be mentioned that Section 69A3 provides for specific penal consequences in case of non-compliance of directions issued under Section 69A of the Act. The penalty prescribed under Section 69A3 for the offence of non-compliance of the order is imprisonment for a term which may extend to 7 years and or fine. Even that did not deter the recalcitrant petitioner. The central government in its discretion did not choose to prosecute the petitioner for the offence in question. It hardly needs to be reiterated that constitutional courts do not come to the aid of litigants whose hands are soiled or who are indolent. In the above circumstances, this petition, being devoid of merits, is liable to be dismissed with exemplary cost, and accordingly it is. Petitioner is levied with an exemplary cost of rupees 50 lakhs only, payable to the Karnataka State Legal so-and-so. My lord, in appeal, this was, my lord, reduced
25
to
lakhs.
25 lakhs, my lord. My lord, thereafter, my lord, I have quoted judgment after judgment, my lord,
Yes.
that,
But one clarification, sir.
yes, my lord.
Article 19, yes, is citizen centric. 21 again is
Natural.
not natural person, or not the company or whatever. Article 14 is all pervasive.
My lord, Article 14, my lord, it is a possible view.
Yes.
When I am assisting your lordships, I may not, my lord, be constrained with the facts of a particular
Correct.
case. But, my lord, in my view, a foreign company trying to do business in India may perhaps not have the locus to say that the policy is arbitrary. Because you have chosen to come here and abide by the law of the land. The law cannot be challenged as arbitrary after coming into it. My lord,
That's
they can incorporate an Indian subsidiary. Look, when petitioner wants the locus standi and a right to be heard, let them say that in the event of their failure under 69A or their failure under Rule 3(1)D, who will be the person who will be liable for prosecution? Let them say, Manu. At least that is what is expected of a petitioner who is invoking a discretionary, equitable jurisdiction of the High Court under Article 226. Let them say. There are no stakes in India. Even grievance redressal officer was appointed after years, after our repeated demands that my subscriber in India wants to raise a grievance, to whom it is to be raised. You must have someone in India. Thereafter that happened. My lord, this is not a forum where I urge my grievances against individual my lord, intermediaries. But at least if they want a hearing, let them say, in the event of my lord 69A non-compliance or 31D non-compliance, who will be the person who will face prosecution? Lord, the judgments, my lord, are Charanjit Lal Chaudhary.
Yes, yes.
My lord, all judgments are aware, my lord, lordships are aware.
Yes.
My lord, only the most recent is H. My lord, that is INSAN, Indian Social Action Forum.
Yes.
So this was some NGO. The court says the NGOs have no right. You are not a natural person. You have no right under 19(1)A. Lord, I have also given, my lord, these case law in detail, Lord, from subsequent page onwards.
Yes.
My lord, I am not reiterating.
Yes.
My lord, Sahyog portal, I have already
Already
pointed
yes.
out, my lord. These are my respectful submissions. Lord, these are my respectful
That's
submissions.
what- yes.
Lord, I'll just place 2-page, my lord. Just encap. I have already argued, so I'm not reading it, my lord.
Yes.
But the same thing which I argued today, I have just, my lord, recalibrated and placed it for the propositions of nothing on facts. My lord, the laws compilation, my lord, for your lordship's ready reference, though I have quoted the relevant parts, but I'll place it, my lord, with the court master,
Yes.
so that if your lordships would like to go through it, your lordships can go through.
Can I
Lord,
request one thing to both of you in sense?
Yes,
Because the documents, I think, run into several thousands of
yes, your
pages.
lordships are right.
If you can give a soft copy of what all you have placed
We shall do that.
in a pen drive or whatever.
We shall do that.
That would
What
be
we
helpful
do,
for,
we'll not coordinate,
Yes.
but their documentation can have P21, P22, etc.
that's what-
We would have
if you-
R21,
yes,
R22,
yes.
so that your lordships can
Yes, we will.
differentiate.
If you can.
That we will.
Not for
At the end,
That will
cutting and
coordinate with
putting
each other.
no, after you finish your rejoinder submissions, if
yes.
this is done, it will be helpful.
we will do that.
Yes.
We'll do
that.
Because
It is
so
really-
many papers are there.
It was really a privilege assisting your
No, no,
lordship.
it is,
My lord, when the honorable
enlightening.
court thinks before, my lord, you can utter a word, but you have to be very careful also, and it's a pleasure. It was really, my lord, a
And from my
privilege.
side, my lord, I want to say something. My lord, normally, my lord, we pay to acquire knowledge. But now, my lord, I am paid to acquire knowledge.
No, lad.
I said is illuminating and
Of course.
enlightening.
Lord,
course.
Lord, I have learned a lot from my learned senior, my lord, and I have said that to him also outside the court.
Yes.
I'm really grateful for his compliments, my lord. I'm grateful to your lordship.
Yes.
Obliged.
My lord, I just to end, my lord, on a good note, that account has been suspended.
Which account?
That
Supreme Court of Karnataka.
we got information. My lord, we are a responsible business house. All that I want to say is only that.
So my oral submission was treated as 3(1)D
Coming from you,
and
no, no, give,
they acted on it. That's what we want.
Acted on now?
And yes,
I think it's
Right
done.
now?
No, I think it was done now. I
No,
don't
no,
know
right
when it was
now,
done.
right
I don't know
now.
when it was done. But anyway, my lord.
That is
My lord,
why we call
if something,
Sahyog.
my lord, if
That is why-
something comes from my learned friend, I have no difficulty, my lord, my learned
No,
friend, with
that's
agency
why.
of the government.
Allah, this is Sahyog, cooperation.
so therefore, my lord, when the AI
It was not
judge-
even a verified, my instructions are, it was not even a verified account. It is some stray stuff, somebody put it. And it has been, no, the statement made was that it has gone through our filtration process.
Lord, we
That
so
is
far
not
as
true.
your lordship's AI generated was concerned, I said you send it to me. But he said, no, I cannot send it. The moment it goes from A to B,
Yes, it becomes circulation.
parallel.
Yes,
So
yes,
it has remained in the storage of my officer, but I'm not showing it to my learned, my lords, my lord. But it says, the lordships are sitting here. Your lordships are speaking in your lordship's voice, which is available in the
Yeah, in the net,
public
yes.
domain. And your lordships are saying something which your lordships would never even think of saying. That is, my lord, the danger. And that is why, my lord, new problems would need
New solutions.
statutory solutions, my lord, which should be least intrusive. No, that is the respect. Obliged. Yes.
Yeah, when will you?
When were the offices?
Tuesday, Monday or Tuesday? I think by next week I want to finish it off.
My lord, can it be little more time? My lord, I have to, as I said,
Next Friday?
As I said a little earlier, my lord, I have to cope up with my learned friends
No.
who are so well versed in the subject. I
No, no,
have
no,
to
I'm
catch
not
up, my
with
lord.
any
I have to
subject.
catch up.
No, 25th,
My lord, can I?
1 week,
25th? No, no, wait.
that should be enough.
Yes,
But
25th.
just on the lighter side, when my learned senior friend says I am well versed with the subject, I must confess that I am the least tech savvy person in my team. I can't, my lord, I can't operate most of the, my lord,
But
systems.
I
or
don't
what-
think, my lord, my learned friend has been engaged to, because he is either tech savvy or not tech savvy.
I am not tech
He has been engaged, my lord, because of his erudition in law.
I'm grateful.
Yes.
Grateful.
So we'll take it on 25th.
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 Whatever
Your
time your
lordships-
lordship indicates, my lord.
Lordships-
25th.
In fact, I would request some time, so if we can have the same facility that your lordships have
10
now given,
10 a.m.
10 o'clock, my lord, so that it will give you over, my lord, that day.
my
I'm going to take some
lordships,
time.
may-
I'm going to take some time.
Pardon my personal presence.
No problem.
I'll
On the
listen
we-
to my learned
on the
friend, my lord,
VCs.
virtually.
Yes, yes.
Of course, my
So,
lord.
no, you take.
Friday is it?
No, you take your time, no problem.
Let's,
You take your time, I'll take it on
Great.
25th, but we should try to finish it on 25th.
I will,
So that-
my lord, I assure your lordships, my lord, I'll do my very best and try to.
On the lighter
try
side,
to-
I completed by 12 o'clock.
Ah,
But
yes.
There is a real life incident of Justice Blackstone. He was known for his ready wit. Before the argument start, he stated that within what time your submissions would be over. The counsel says, my lord, 20 minutes. And his question was, that is okay, but would you stop thereafter? Generally, we do not stop even after our submissions are over.
In fact, my lord, there's another incident that happened, my lord, in Madras High Court during those days when there were English judges. My lord, the English judge, my lord, the judge said in his very stylish accent, "How long, Mr. Counsel, will you take?" and looked at the clock. And the counsel, my lord, in his typical Tamilian accent, said, "My lord, your lordships are looking at the clock. Please look at the calendar."
How many days I will take?
Yes, yes,
It's just a lighter way.
absolutely. Obliged, Your Lordship.
Grateful,
Yes.
my lord, great.
25th, 25th, yes, that's all. Please do, whatever, yes. 25th, but 25th, sir, try to
Yeah.
finish it.
Yeah, I understand. In fact, what I'll do, my lord, is
We'll close it on 25th.
to put my submissions written, the rejoinder submissions in writing, so that, my lord, when I take your lordships through that, I will be brief
That's
and to
what
the
the
point.
SG sir has done now.
Yes,
Mr.
exactly.
Corbett, he has taken.
Yes, my lord, yes.
So,
In
if
fact,
you-
we have given our
Yes, you
submissions,
also
initial
given, yes,
submissions
yes,
also.
it's there.
So this will be
You
additional.
took me through that only, where
Yes,
make
my lord, I will-
submissions
I
and
will.
elaborating it,
I will,
amplifying
I
it.
will, I will,
Same thing.
I will.
So 25th we'll try to close.
Great.
Well, I'll make the same arrangement of 10 a.m.
Yes, ma'am, we'll be here.
Yes.
We'll be here.
And take the other councils later after this.
Wait,
All right.
yes. Grateful, grateful.
ಇನ್ನ ಫೈಲ್ ಆಗಿಲ್ಲ
Ravi Shankar, sir.
Lordships.
Next matter nimda.
Please. Lords, in that, BDA has served the counter, my lords, only day before yesterday. Lords, yesterday I went through it, it requires a rejoinder because they have made some factual assertions.
But there is-
I may be accommodated to 22nd or 23rd, not 22nd or 24th. 23rd, there is some,
24th.
24th, my lords.
We have some urgency. BD has no
Urgent.